Kennedy of Louisiana.
Hello, hello, Judge. If you are a lawyer or an American, I guess it doesn't get any bigger or better than this. Congratulations. In addition to honoring the wonderful state of Minnesota, and unless you correct me, I am going to assume that your purple attire is also meant to honor LSU in my state. And if I squint real hard, I might call it Marion blue, the colors of my Southern University in Louisiana. I want to compliment you and the Biden White House for selecting Senator Doug Jones to advise you. Senator Jones knows the Senate, and the Senate knows Senator Jones. And we know him to be quite the intellect, but more important, we know him to be a person of good judgment and goodwill. And I'm glad that you've been listening to him. I hope we will be able to use this hearing today to talk about, if not implicitly, at least implicitly, two subjects. The first is the legitimacy of the United States Supreme Court. Where does the court get its legitimacy? What can we do to enhance it? Judicial legitimacy is important. I don't need to tell you that. I'm rather fond of the Constitution. I know you are too. When members of the United States Supreme Court interpret it, I want the American people to believe them. I want the American people to say, well, I may not agree, but the men and women who made that decision are intellectually honest and people of good faith. One of the primary roles of the United States Supreme Court is to uphold the rule of law. And sometimes justices have to uphold the rule of law when it's not popular. Sometimes justices have to uphold the rule of law when it's not popular with the majority of Americans. Boy, that's tough. It's also important. Sometimes, not generally, but sometimes the majority can mean that just all the fools are on the same side. And that's what the court's there for. And I'm rather fond of the Bill of Rights, too, and I know you are as well. I've never believed that the Bill of Rights was there for the high school quarterback or the prom queen. They're covered by it. But the Bill of Rights is there to protect the rights of people who don't see the world exactly like everybody else, or who don't look exactly like everybody else. Now, unfortunately, through history, we have had people, some well-intentioned, who tried to delegitimize the Supreme Court. We had a president way back when who tried to impeach a Supreme Court justice. We had another president who wanted to pack the court. I remember the impeach Earl Warren signs during the Warren Court. And most of the people who want to delegitimize the Supreme Court believe that unlike our founders, in my judgment, believe that that members of the Supreme Court ought to be and are politicians in robes. They believe that the United States Supreme Court ought to be a mini Congress. They believe that the law is not the law. The law is supposed to just be politics practiced in a different way. And they believe in court packing. And they're wrong. Number two, I hope today that we can use this as an opportunity to talk about, if not explicitly, at least implicitly, that's what I'm going to try to do, the appropriate balance between representative government and declarative government. Now, in representative government, as you well know, people, through their elected representatives, make policy. In declarative government, policy is made by the unelected, the administrative state, and the federal judiciary. Now, both are important. Both are important. I'm not saying this is a zero-sum game or either or. But what's just as important is we have the appropriate balance between representative government and what I'll call declarative government. I mean, we have an administrative state. Did any of us ever think it would get this big? Is that healthy? We need to ask ourselves that. Is it really healthy to arrive at a circumstance where the administrative state passes 35 laws a year to our one? Is it really healthy to have an administrative state that makes its own laws, interprets its own laws, and enforces its own laws before courts, with respect to which the administrative state appoints the judges? I think that's a fair question to ask. In terms of, with respect to declarative government in the Supreme Court and the federal judiciary, federal judges have enormous power. They have to, but they do. They have enormous power. You're appointed for life. You can't be unelected. Your salary can't even be reduced. And you have to have that power. Judicial power is important. So is judicial restraint. I believe that the appropriate role of the federal judiciary is the following. Federal judges don't make law. They don't tell us what the law ought to be. They tell us what the law is. Now, I said primarily because, of course, sometimes federal judges make law. I mean, you make the law of the case. You decide a case. You have to tell us what reasonable means in terms of searches and seizures. You have to help us define restraint of trade after we pass a statute. So, of course, judges make law. But I'm talking about the proper balance. I'll leave you with these last thoughts, and then I'll yield back my time. I want you to hear the words of one of, in my opinion, is one of our most distinguished Supreme Court justices. I'm going to read his words. The American people love democracy, and the American people are not fools. The people know their value judgments are quite as good as those taught in any law school, maybe better. Value judgments, after all, should be voted on, not dictated. I look forward, Judge, to getting to know you better. And congratulations, Mom and Dad.
Thanks, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chair. Judge Jackson, welcome back to the Senate.
Senate Judiciary Committee will resume, and the questioning is to Senator John Kennedy of Louisiana.
Thank you, Mr. Chairman. Judge, I have enjoyed listening to you today. I find you to be very intelligent and very articulate. I'm still a little uncertain about how you think, how you approach cases, deciding cases, and we'll talk about that in a moment. I'm not going to ask you, nor should I, how would you would decide a case. And I'm not going to ask you, nor should I, to tell me whether you think a particular precedent is a good precedent or not. So, but I am going to talk to you about the law. But first, you don't support efforts to delegitimize the United States Supreme Court, do you?
Senator, I have nothing but esteem for the United States Supreme Court, for my hopefully future colleagues on the court, and the work that the court does.
Can we agree that the calls to pack the court delegitimize the court?
Senator, it would not be appropriate for me, in my view, to comment on calls to pack the court, as you say, to increase the number, to do any structural changes. Those are policy determinations for Congress. What the consequences of those are policy considerations for Congress. I'm just looking forward to working with the brilliant people who are there at whatever size Congress decides if I'm confirmed.
Well, the calls to pack the court don't legitimize the court, do they?
Well, Senator, I think that would be for you to decide.
I'm asking your opinion.
Respectfully, Senator, I'm not in a position to give my opinion on issues that are policy issues concerning the court, and not something that a judge would have to consider or should consider, in my view.
Yeah, but you're a citizen.
Oh, I am.
And as best I can tell, a very good one. I don't understand why you won't weigh in on this issue. Tell me why you won't weigh in on this issue.
Senator, I feel so strongly about ensuring that judges remain out of political debates. And this is something that is being debated. It is something that other nominees, Justice Barrett was asked about the same sort of thing and also declined to give her opinion. And I think that was the right way to handle this particular issue.
So you think Judge Barrett was right to dodge the question?
I think that each judge has to make a determination when asked about whether they would like to speak to issues, and I know that I'm not comfortable, in part because I'm so committed to making sure that there's confidence in me in terms of public confidence in my ability to stay in my lane, my ability to not speak to contentious political issues.
You have an opinion, though, don't you?
Senator, any opinion that I would have is not something that would ever come up in my work as a judge, something that I would ever rely on. This is a political issue for Congress.
But do you have an opinion, Judge?
Not a strongly held opinion, actually.
But you have an opinion.
I haven't really thought about it, but I hear the arguments on both sides, and I understand it to be a political issue.
Now, Judge, you're very intelligent and you're very articulate, and I know you're very well informed. You're telling me you don't have an opinion about packing the United States Supreme Court?
Senator, I have opinions about a lot of things. I don't have an opinion that I think it appropriate to share. I work very hard to set aside my opinions when I'm thinking about cases, which is the work of a judge. And so this particular issue is one that is very contentious, as you say, one that's in the province of Congress, and one that I think it not appropriate for me to comment on.
I understand that. But I think it would tell us a lot about you if you would answer the question. I'm a little confused about your answer earlier. It's probably more my fault than yours. Do you have an opinion about whether these efforts to pack the United States Supreme Court delegitimize the court? Do you have an opinion?
Senator, I have an opinion about the efforts. It's not an opinion that I think is appropriate for me to share. And so therefore, I don't have anything further to add.
So you do have an opinion, but you don't want to share it. Is that?
I don't think it's appropriate for me as a nominee to comment on a political matter that is in the province of Congress.
Well, in deciding to join the United States Supreme Court, if you're affirmed, wouldn't it make a difference to you whether you're one of 9 or one of 28?
Would it make a difference?
That impacts the judiciary? That involves the judiciary?
Senator, it certainly involves the judiciary. I would be thrilled to be one of however many Congress thought it appropriate to put on the court.
Okay. So you'd be okay if it was 28?
If that's Congress's determination, yes. The Congress makes political decisions like that.
Okay. A couple of my colleagues ask you about the Supreme Court overturning precedent. Now, it doesn't happen every other Thursday, but it's not what's the word I'm searching for, Judge? It's not extraordinary that the Supreme Court overturns precedent, is it? I mean, it happens. I won't say a lot, but it's not once every 50 years. Am I correct?
You're correct that it's more frequent than once every 50 years, for sure. Yes.
And so it happens.
Yes.
And you talked earlier briefly about the different factors that the court considers
Yes.
in deciding. Give me a couple of those. Hit that another lick for me and just give me a couple.
Whether the decision is egregiously wrong, whether there's been reliance on the decision that is being revisited, whether the decision is workable or unworkable, the one that they're looking at, whether the facts are new facts have come to light, or the facts have the circumstances are such that there's now a new understanding of the prior facts, and whether the case law in the area has shifted.
And in fact, those are the factors that the Supreme Court listed 3 years ago in Janus, are they not?
Those are the factors. I don't have the Janus opinion in front of me, but those are the factors that the court uses when it determines.
Janus overruled, I think Senator Hirono talked about it. Janus overruled Abood.
Yes.
Dealing with whether labor unions can require non-members to pay dues. Remember that case?
Yes.
Is the age of the case, a factor in whether the Supreme Court will overrule a precedent?
I think age relates to the reliance factor. I think the longer an opinion has been in effect, the court has considered that to be relevant to its determination of reliance.
But sometimes the court looks at it not just in terms of reliance, they look at it from the other side of the age issue, and that is that maybe facts and circumstances and science have changed. Do they not?
I believe that is part of the change circumstances factor.
So the Supreme Court is more likely to overturn a case, which would not be that extraordinary, if the precedent were 49 years old as opposed to 4.9 years old.
I'm sorry. Can you repeat the question? I'm just
well. You said that the older the case is, one could make an argument that the reliance interest would be great. But you also said, I think, I don't mean to put words in your mouth, but the older the case is, the more facts and circumstances and science could have changed. So that would argue in favor of overruling it because of a change of circumstances. Did I get?
It might. These are all different circumstances that the court could consider under this multi-factor test.
Okay. But all things being equal, let's say a decision 49 years old versus 3 years old, like Janice. The older decision is more likely to be overturned, you think, based on your experience?
Oh, I don't know that I could make that prediction. I'm just saying that one of the factors, the reliance factor, the age of the opinion and how long people have been relying on it,
Yes, ma'am.
can be relevant to, it is one of the factors that the court considers.
Right. Okay. Let me jump gears here. I took some notes. You talked earlier about how you decide cases. I'm going to kind of summarize this. You said you clear your mind of any bias. You read everything. You read the briefs and the record, and then you apply the law. That's your methodology. You said you're not an activist judge. You said, am I right?
Yes,
You said judges are not politicians,
that is true.
and judges should stay in their lane.
Yes, sir.
Tell me again what you mean by stay in your lane.
What I mean is that in our system of government, under the Constitution, we have a separation of powers, and each branch has their own sphere of responsibility. To say stay in your lane is the shorthand that I'm using for indicating that judges should not be policymakers, that those responsibilities are left to the elected branches, and that judges are to interpret the law, not make the law. And I use it to refer to the part of my methodology that is mindful of the constraints on judicial authority.
Okay. Well put. So let me ask you. We can go to the Constitution, let's say the Bill of Rights, to narrow the discussion, and read about our explicit rights. Religious freedom, our right not to be unreasonably searched or seized, freedom of speech, they're right there. That's why they call them explicit. But the court has ruled we have a bunch of unenumerated rights. Am I correct?
The court has determined there are certain personal rights related to individual autonomy that are implicit in the concept of ordered liberty or deeply rooted in our nation's history or tradition.
But they're unenumerated.
Yes.
Okay. Should these unenumerated rights that only Supreme Court justices can see, should they be decided by the people through their elected representatives or by the unelected federal judiciary?
Well, Senator, the Supreme Court has interpreted the 14th Amendment to have a substantive component, and I'm not in a position to critique the court in terms of its precedents. That is the precedent of the Supreme Court.
Right, right. Well, let me ask you this. What is a fundamental right?
The court has interpreted the 14th Amendment's due process clause to include a substantive component and not just a procedural component, meaning the 14th Amendment guarantees due process, and the court has interpreted it to mean that with respect to certain rights, individual rights concerning intimacy, certain things like the right to contraception, the right to child rearing. There was a case of the Supreme Court that talked about making decisions for children in terms of visitation with respect to conflicts with grandparents, marriage.
Right. I'm with you.
These sorts of rights, the court has found, are implicit in ordered liberty, as I said, or deeply rooted in our nation's history and tradition.
The right to assisted suicide, is that one of those enumerated or unenumerated rights?
I believe the court found that it was not.
Which body do you think is better able to make that decision, the Congress or the federal judiciary?
Well, Senator, the Supreme Court has interpreted the Constitution, and the Supreme Court has the authority under our constitutional system to interpret the law.
Right.
And they've made the determination that the Constitution includes those unenumerated rights.
Yeah, but here's the thing, Judge. Maybe a better example, it's a very hot topic today, the right of a transgender woman to compete in women's sports. Do you think Congress, the people ought to get to decide that through Congress, or the judge can just find it as an unenumerated right, a penumbra of the Constitution?
Well, Senator, that the topic that you raised is something that is, as you say, a hot topic today and could certainly be litigated. So I'm not in a position to say more about whether or not it's actually one of the unenumerated rights.
Well, I don't want to ask you how you'd rule, but would you have any problem saying, okay, if that case that is litigated, saying this is a political question? Whoa, stop! I'm staying in my lane. Congress needs to decide this case. The people need to decide that through their elected representatives.
Well,
would that be appropriate?
Well, respectfully, Senator, that is a decision. In other words, you say, I'm not asking you to decide it, but in every case, the determination about whether or not something is a political question or whether or not the court has or has not jurisdiction is an issue for judges, and so I'm not able to speak to it.
Okay. All right, well, here's the thing about the fundamental rights. That's why I asked you about the definition of them. These are unenumerated rights now. I'm not talking about right to free speech and freedom of religion. The court has said repeatedly that there is no test for a unenumerated fundamental right, that the determination has not been reduced to a formula. Am I right?
Well, they've given those standards in the cases in which they have been evaluated.
In some cases. Sometimes the court talks about these unenumerated fundamental rights have to be deeply rooted in the nation's history and traditions. Sometimes the court says, they change the language, these unenumerated rights like the right to assisted suicide we talked about. It's a potential unenumerated right. The right has to be implicit in the concept of ordered liberty. But you've read Obergefell. In Obergefell, I think Justice Kennedy wrote that opinion. He didn't bite. In fact, he cited with approval Justice Harlan's dissent in Poe v. Ullman. And Justice Harlan said, look, there's no formula here. Justice Harlan always said, you have to go case by case. Can you understand why some Americans go, wait a minute, are justices, these are unenumerated rights, are justices interpreting the Constitution, or are they just deciding a right when they get 5 votes, and it's just a moral conviction?
Yes, Senator, I do understand.
Okay. Well, when you talk about judicial restraint, where does the restraint start with fundamental right? Let's take the 9th Amendment. Okay? What's it say? I know you know because you talked about it earlier.
Well, it says that it indicates that there are rights that the fact that there are some enumerated rights in the Constitution doesn't mean that there aren't others.
And how are we supposed to determine what others there are?
I think the Supreme Court has not found any others coming from that particular constitutional provision.
Could they?
I can't speak to that, Senator.
I mean, it's possible, right? If they get 5 votes, right?
Well, anytime the Supreme Court has 5 votes, then they have a majority for whatever opinion they determine.
Yeah. But do you think that would be a prudent course of action to start creating fundamental rights through the 9th Amendment, unenumerated now, without consulting Congress?
Senator, I can't speak to a hypothetical about whether or not it would be a prudent course of action for the Supreme Court to hold that there were other rights in the 9th Amendment. That's
well, the reason I'm asking, Judge, is you've talked a lot today about judicial restraint. And that's kind of like being for children and prosperity. We're all for children and prosperity and judicial restraint. But the rubber meets the road when you get down to, well, what does that mean? What does that mean?
what it's meant for me, Senator, is what you've seen in my opinions in the way that I've approached issues that have been before me, in my fidelity to the restraints that exist in the law in terms of the exercise of judicial authority. That adherence to precedent, for example, is something that I do, and even in cases, as you heard me discuss earlier, in which they're not binding precedents, I find that the court needs to take into consideration what has previously been determined and not be a policymaker in my decisions.
Okay. Well, here's what's bothering me is too strong of a word. It sounds pejorative. Here's what I'm uncertain about. And please don't take this the wrong way. How do we know? I'm not saying you would do it, but how do we know that, since I can't seem to flesh out this judicial restraint and the limits of it for you, how do we know that if you get on the court, you won't say, well, you know, Congress can't get anything done, and there are all these issues that we need to address. And so I think the United States Supreme Court ought to create all these rights through the 9th Amendment. What would you say to that if somebody made that allegation?
Well, Senator, I think that I have a record as a judge in terms of having been given responsibility, having looked at cases, having decided issues, and that my record demonstrates how I handle cases. I'm not in a position to hypothesize a circumstance in which a case appeared that raised a question about the recognition of an unenumerated right and whether I would say under those circumstances that I couldn't find such a right because that's a hypothetical, because I decide cases and controversies that come before me, because I'm a nominee and I can't speak to hypothetical scenarios about how I might rule in the future with respect to cases.
Boy, the time goes fast. Let me ask you one other question.
Yes.
This business of having unenumerated rights through substantive due process, there's no textual basis for that. The court just started doing it, okay? I'm not asking you whether you think it was good or bad, because it's clear to me you don't want to share your thoughts on that, and I get it. Feel better if you would, but I get it. But don't you think the fact that our founders included a way to amend the Constitution is a testament to the fact that they were saying, here are your rights, we're writing them down. You can all go to the Bill of Rights and read them. And if you want more, we put in a way to amend the Constitution.
I do understand that argument, and there are people who argue that. The Supreme Court has determined that the Due Process Clause
Yes, ma'am.
includes a substantive component.
Okay.
And I understand the critiques of that view.
I'm going to try to get in two more. Boy, the time flies. When does life begin, in your opinion?
Senator, I don't know.
Ma'am?
I don't know.
Do you have a
I don't-
belief?
I have personal, religious, and otherwise beliefs that have nothing to do with the law in terms of when life begins.
Do you have a personal belief, though, about when life begins?
I have a religious view
Religious belief?
that I set aside when I am ruling on cases.
Okay. When does equal protection of the laws attach to a human being?
Well, Senator, I believe that the Supreme Court, actually, I actually don't know the answer to that question. I'm sorry. I don't.
Okay. All right. You're familiar with the warrant requirement, I know.
Yes.
Okay. What if Louisiana said, we don't want to follow the warrant requirement? Would that be legal?
Are you positing a statute of Louisiana that we're not following, or individual law?
Yeah, it's called a statute.
Well, Senator, I'm thinking about all of the potential legal arguments that could be made. I can't answer the hypothetical about whether or not it would be lawful or unlawful.
Can you think of an instance where a state could say, we're not going to follow the warrant requirement. We're going to write our own warrant requirement?
I've never heard of that happening.
Yeah. What if Article 1, Section 5 of the Louisiana Constitution is our state unreasonable searches and seizures? Couldn't we say, we're not going to follow the federal interpretation? We're going to make it stricter under the state constitution.
Well, the state can also.
And in fact, under the state constitution, we're going to say a warrant is required in every instance. Don't give me this stuff about plain view and hot pursuit. You serve somebody, you better go stop and get a warrant. Now, I'm not saying Louisiana would do that, you understand? And I'm not saying they should or shouldn't. They can do that, can't they, under their own state constitution?
They can provide more protection than
Yeah.
the federal government. Yes.
Why- How can they get away with that under the supremacy clause? You got to go fast because Durbin's about to cut
Yes,
me
I'm
off.
sorry. How can they get away with providing more protections
Yeah.
for people?
Yeah, under the supremacy clause.
Because it would depend on whether or not it conflicted with federal law. It doesn't conflict, I think, if the state provides more protection.
We call that the adequate and independent state ground doctrine, right?
Yes.
Okay. All right, I'm over, but only about 22 seconds. So I'm going to land this plane, and we'll take off again tomorrow.
Thank you.
Thank you.
Thanks, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chairman.
Committee will resume with Senator Kennedy of Louisiana.
Thank you, Mr. Chairman. Judge, I want to continue where we left off yesterday and try to get, if I can, get to the essence of this tension between judicial power and judicial restraint. You have testified, and stop me if I get this wrong, that judges should stay in their lane. And I think it's fair to say that one of your definitions of staying in your lane is that judges don't make policy. Am I right so far?
Yes, that is correct, Senator.
Then how do you explain or help me understand the following? We have a judicially created doctrine with no textual basis either in the Constitution or a statute called substantive due process. And through substantive due process, our federal courts, let's just narrow it down, the United States Supreme Court has given itself the authority to read into the Constitution unenumerated, unmentioned rights. Not read the Constitution and say, well, there it is, freedom of speech. But these are unmentioned, unenumerated. Isn't that making policy?
Senator, the Supreme Court interprets provisions of the Constitution, and there are provisions of the Constitution that require interpretation because they don't just on the text in every circumstance answer the question before the court. So due process, what does that mean? And the Supreme Court has, the words due process do appear in the text of the Constitution, and the question is what is covered by that provision? The Supreme Court, oh, sorry.
I was just
Go
going to say,
ahead.
but when they do it, aren't they making policy?
Well, Senator, the role of the judiciary is to interpret the law. To the extent that somebody argues to the court that there's been a violation of the due process clause of the Constitution, it is within the role of the court to determine what that means, whether the person is correct that what happened with respect to their case violated the due process clause. And so there's an interpretive function that is a part of the judicial function.
Here, let me see if I can put a finer point on this. it's not the right so much. It's how the right is created. That's why I asked you yesterday whether you think that these unenumerated, unmentioned rights ought to be decided by the people through their elected representatives versus the federal judiciary. Let's take two rights that I talked about yesterday, the right to assisted suicide, the right of a transgender woman to participate in women's sports. I can see how, I'm not predicting that it will, but I could see how the court, either through the Due Process Clause or the Ninth Amendment, could find those rights in the Constitution. As we talked about yesterday, the Supreme Court looks to me like they've adopted the policy of there is no test for a fundamental right. There are several tests. And in Obergefell, Justice Kennedy cited with approval Justice Harlan's dissent in Poe v. Ullman, which says there's no test. We go case by case. And but I know there are tests, like I'll get the language here somewhere. I've got it. I don't want to look it up, but implicit in the concept of ordered liberty, and you've talked about that. Here's a new one that Justice Kennedy talked about in Obergefell. He said, inherent in the concept of individual autonomy. Well, I can see how if the court with 5 votes wanted to say, even though the right to assisted suicide or the right of a transgender woman to participate in women's sports, I can see how somebody, you're smart, you could write an opinion and say that's inherent in the concept of individual autonomy. And maybe, again, it's not the right, it's who's supposed to decide. And that's where the judicial restraint comes in. I mean, don't you think that the values of ordinary Americans and their ability to decide these issues are just as good as those of 5 members of the Supreme Court?
Thank you, Senator. There are policy determinations that are made by vote, and absolutely in the democratic process, people get to decide things. The question and the difficulty is when you have a constitutional scheme of government and you have a constitution that does protect certain rights, and it does so in a circumstance in which those rights, whatever they are, enumerated or not, are might be things that the people have disagreed with. That's the tension. That although we have democracy, as we do, and people vote and should absolutely, we also have a constitution that protects certain rights against the sort of majority will about those things.
But the rub, of course, is, I agree with everything you said, but the rub is these are unenumerated rights.
Yes.
They're read into the Constitution.
Yes.
And what troubles me, I'm not saying I disagree with all the rights that the Supreme Court has created, but I don't think we talk honestly enough about how those rights should be adjudicated. For example, I'm not asking you to comment on this. I think you already have. But when President Biden announced your appointment, or at least shortly before, he talked about, I want a judge that's going to read new rights into the Constitution through the Ninth Amendment. And I'm sure some Americans are saying that's a good thing, but you got a lot of Americans going, hey, wait a minute. Supreme Court isn't elected. A couple years ago, Chief of Staff Ron Klain wrote an opinion piece, and he said he hopes, and I'm going to quote, that, quote, I hope the Supreme Court will intervene whenever the nation's conscience and laws need a jolt in a progressive direction. That's policy making. Do you agree with that statement?
Do I agree with the statement that that's policy making, or
No, did you
I'm
agree
sorry,
with what the chief said?
Senator? That's a political statement made by someone in the executive branch.
Okay.
I'm
I'm not going to push you on that. I get it. It's not a good time to make the chief of staff mad, is it? Well, I hope you'll keep this in mind, Judge, if you're confirmed. I mean, this is what judicial restraint is all about, and I think part of the division in our country. America's a big, wide open, diverse, sometimes dysfunctional, but sometimes imperfect, but basically good country. But we have different values. That's part of our diversity. And I think our country works because of our system of federalism. The values in Louisiana may be different from the values in Maine. And if you don't like what's going on in Maine and you like what's going on in Louisiana, you can move. But as our federal government has gotten bigger and bigger and bigger and bigger, what is developed, at least here in Washington, is this managerial elite. And when I say the managerial elite, I mean the entrenched politicians. I guess I shouldn't say entrenched because that's pejorative, but we do have a lot of politicians that have been here a long time. They're members of the media that are part of the managerial elite. They're members of the administrative state. They're academics that are part of it. There are a lot of corporate phonies that are part of it. And many people in this cabal think they are smarter and more virtuous than the American people. And that they ought to set forth how people should live their lives. People should shut up and just do what they're told. And if they behave, maybe the managerial elite will let them eat meat occasionally. And I think that's part of the division in our country. And I think to some extent, the Supreme Court, I don't want to say contributes to it, but it needs to be mindful of this. I'll give you another example. And this case bothers me. I want you to explain it. I think Lindsay talked to you about it, but I don't know that. I want to hear you explain it. It's Make the Road New York versus McClellan. You remember that one?
I do.
Yeah. Here's the way I read it. Congress, we, in a rare moment of consensus, gave DHS the sole and unreviewable, those are not my words, they're in the statute, the sole and unreviewable right to determine when illegal immigrants should be removed on an expedited basis. The Department of Health of Homeland Security, taking this statute, decided to use its sole and unreviewable authority or discretion to state that we're going to have expedited removal of all illegal immigrants who've been in the U.S. less than 2 years. And you said no. And not only that, but you issued a universal injunction. And I don't understand why. You talked about judicial activism, and I don't see how clearer Congress could have been. Now, the D.C. Circuit reversed you, but I want to hear your reasons for issuing that nationwide injunction.
Thank you, Senator, for allowing me to address that decision in that case. The statute at issue gave discretion to DHS to determine the amount of time that a person needed to have been in the country between 0 and 24 months in order to be subject to expedited removal, as opposed to the normal removal process in the immigration system. The statute said that DHS had sole discretion, meaning I interpreted, meaning no other agency was to have the authority to make that determination. And the statute said that DHS's determination in that regard was unreviewable, meaning it was final. Once, this is how I'm interpreting, meaning that once the decision was made, it was over. Nobody else gets to review. The court doesn't get to say, no, you're wrong if you pick 12 months, for example, or 16 months or 24 months, as they did in this case. The statute did not speak to whether Congress intended, with that grant of very broad discretion, to exclude another statute that Congress has passed that directs agencies, when Congress gives them discretion, the other statute, the APA, directs agencies as to how they go about making decisions that Congress has given them the authority to make. The APA is a procedural statute. It says to agencies, when Congress gives you discretion to make a determination, you have to do so in a way that's not arbitrary and capricious. You have to use your expertise.
Right.
In certain kinds of decisions, you have to use notice and comment in order to get information. It's procedural. The claim that was being made in this case, as I read it and understood it, was not that the agency couldn't pick 24 months, because obviously Congress had said in the statute you can pick between 0 and 24 months. The claim that was being made is that the agency picked 24 months arbitrarily in violation of Congress's direction about how you go about
The
exercise.
APA was violated?
Yes, the claim was an APA violation. So no one was saying that the statute was violated in the sense that the agency did something that it couldn't have done per the statute, picking 24 months. They said the APA was violated because, this is the claim that they were making,
Sure.
because the agency did no analysis, the agency did no expertise, the agency did not evaluate, okay, if you've been here 6 months, these are the kinds of ties that you have. If you've been here 18
I got
months,
it.
right?
Got it.
The agency didn't do anything. Essentially, according to the claimants, the agency heard the president say, we're going to now do 24 months when everybody else, all of the other administrations up to this
I'm
point.
rushing you because I've only got 2.
Yes, I'm sorry. All right.
What I hear you saying is, tell me if I'm wrong,
Yes.
they didn't follow the APA, in your opinion, which you have to do even though Congress passed the statute? Is that
Well, no, because two things. One is the APA under DC, longstanding DC Circuit case law is presumptively applicable to every situation in which an agency is exercising its discretion. So that's the first thing. It's always there as a background rule. So the DC Circuit has said Congress has to be pretty clear when it decides to exclude the APA, when it's saying, I'm giving you discretion, but you can do this arbitrarily, you can do it however you want. And in other places in the immigration statute that sets up expedited removal, Congress says, we are excluding the APA. We're telling you that with respect to this kind of discretion, the APA doesn't apply.
I got you.
So here I had these two statutes, and there are canons of statutory interpretation that says that you should try to give effect to all of the will of Congress. You should try to read statutes so that they go together in a way if you have these two directives. And there's also DC Circuit case law.
Judge, I got to stop you
All right.
because I got it. I think I got it.
And let me just say, I agree that the DC Circuit reversed me. They disagreed with my interpretation, and that's the way that our system works.
Let me ask this last question. This is a question about based on your experience. Can we agree that if, I want to emphasize if, cocaine is cocaine, that crack cocaine is equal in its danger to powdered cocaine? You with me?
I think so.
One is not more dangerous than the other. If that's true, then the sentencing rules ought to be the same. Okay?
It's a policy matter for Congress. You could make them differently if you
Right.
wanted to.
This is what I want to ask you.
Yeah.
Based on your experience, you've
Yeah.
been on the bench a decade.
Yes.
Is crack cocaine more dangerous than powdered or less or the same?
Senator, that's a policy determination. That's what policymakers do. They look at the evidence related to these things and they decide what's more dangerous.
But what have you seen?
What should I have seen evidence through the Sentencing Commission that the two compositions are chemically similar, so similar as to be indistinguishable. And the commission, for very many years, as a policymaking body, indicated its view that they should be equivalent and lobbied Congress concerning that. And Congress made a determination about, in the policy realm, making it 18-1 instead of 100-1, which is what it had previously been.
Okay. Thanks, Mr. Chairman.
Thank you, Senator Kennedy, and now Senator Padilla. Senator Ossoff, Senator Kennedy.
Thank you, Mr. Chairman. Men are free. The author of this quotation today would probably say people are free. And human life begins on the far side of despair. That, of course, is a famous quotation from a preeminent 20th century French philosopher. That philosopher went on to say, in another way, to be is to act. In other words, all we are, from at least one perspective, is the sum of our actions. Put yet another way, what you do is what you believe, and everything else is just cottage cheese. I found Judge Jackson to be smart, well-versed in the law, and how can I put this? Extraordinarily deft and artful in her ability to speak at length without saying anything of substance on critical questions, especially the limits of judicial power and the importance of judicial restraint. That is not a characteristic solely of Judge Jackson's testimony. It seems that many of our nominees, not just for the United States Supreme Court, have adopted that approach for some time under other administrations. I regret that. For that reason, I spent a lot of time reading Judge Jackson's opinions. She hasn't written a lot of law review articles. That's not a criticism. She just hasn't. And I did take a look at the piece she wrote when she was much younger. But given the length of time, I put more emphasis on reading her opinions. And my conclusion is, and I think the best evidence of that, if you If you take a look at, read one opinion by the judge, I would encourage you to read Make the Road New York case, which was her case on immigration. Well written, but I think her true feelings about the limits of judicial power are expressed in that opinion. She was reversed by the D.C. Circuit Court of Appeals. I don't agree with the judge on where, based on her opinion, she draws the limits of judicial power, and I don't think she places as great an importance as I do on judicial restraint in a Madisonian system of checks and balances and separation of powers, and for that reason, I will be voting no. Thank you, Mr. Chairman.
Thank you, Senator.